Turning our attention to Virginia, a state in which I am licensed as a lawyer, Virginia has a FOIA law, as many states do, that allows for freedom of information. The national government, of course, has one. Many states have their own version, and many states have defined the law in a different way than the federal government as it relates to such things. So the question, of course, is as a matter of its own state law, what records are discoverable, what records are not discoverable? The Virginia Supreme Court has recently clarified this question as a matter of its state law, drawing a bright line when it comes to open meetings that allows for transparency of what government is doing and making sure that people have access to governmental meetings. So let's take a look at this Virginia specific law. In a split opinion, the Supreme Court of Virginia upheld a more expansive definition of what counts as a public meeting. So the FOIA law in Virginia allows people to go to meetings to see what the government is doing, offer testimony perhaps, see what the government, how it's functioning. Your government is for you, so you can see it. And the question is, of course, well, what counts as a meeting? Which, you have to define it somehow. So what counts? The case centered on an impromptu meeting that took place to discuss local unrest in a particular Virginia county after police had killed George Floyd, and posed questions for the high court of what kinds of meetings the public should be notified about and count as public business. So this particular county apparently had some sort of civil unrest of some variety in relation to the George Floyd incident, as many places did, as people were exercising their right to protest, but potentially not in a civic way. There's a big difference between protesting and creating, civil unrest. And so this county is having some sort of struggle with this and has some sort of meeting to discuss, okay, this seems like maybe a problem. Should we do something about it? And the question is the meeting a meeting that was open to the public? Lawyers for the county had pushed for more leeway to hold an informal meeting, arguing public business should be narrowly defined as matters appearing on an official agenda. So it's like, okay, we'd like the ability to just, get together and have discussions that are more informal. And you can obviously see the problem with that, right? Because if you say that, then maybe a lot more things will be quote unquote informal, right? The government will still have official meetings for the unimportant stuff, but maybe a lot more stuff will be informal. So should the government allow for informal meetings? Maybe, but if you do that, if you give them that loophole, then, well, maybe a lot more stuff will be off the books. So that could be a problem. A majority of the Supreme Court of the state rejected the argument in opinion that pointed to the bright line of Virginia's specific FOIA law that states a presumption in favor of open government. To adopt the defendant's construction that a topic cannot be public business unless it appears on a formal agenda would gut open meeting provisions. I mean, it sure could, right? Because there might be a temptation to not put as many things on the public agenda. Oh, we're just discussing this informally among ourselves. Nothing to see here, right? It allowed portions of the board to meet, discuss, and decide business in secrecy. Yep, the Supreme Court has seen the problem. Whether or not this was designed as a ruse to get around things is a debatable question, right? Maybe there was a reason for the board to meet in this way under these circumstances. Maybe this was justified unto itself. But of course, the problem isn't necessarily the meeting. The problem is the precedent. Because if we say that this is an okay thing to do going forward, then maybe we'll see a lot more things like this. So whether or not the county board did a bad strictly in this situation is somewhat less important than the rule that we're creating. And if we allowed this as a rule, that would be bad. So let's not do that. 2 residents had sued the county over a meeting that took place the day after May 30th, a protest some county officials characterized as a riot. So some sort of emergency meeting, right? There was some sort of civil unrest May 30th, and let's have an emergency meeting the next day to discuss it. Kind of rational, makes sense. The lawsuit centered on the gathering to discuss the event. The entire board had an emergency meeting at 4 p.m., but the litigation centered on an earlier meeting at 1 p.m. So there was an official meeting at 4, but an unofficial meeting at 1. This unofficial meeting had 5 supervisors, police officials, county employees, members of the Citizens Advisory Board for Law Enforcement, and 60 members of the community. Seems like a meeting. So it seems like that might be a meeting. Though most of the supervisors attended, 3 other supervisors weren't even invited, apparently, which is also hilarious because they're members of the board, but they aren't even invited to the meeting. But it's okay because it's not a real meeting. But I can't help noticing that you have 5 of the 8 members present, which sounds suspiciously like a quorum. Are we sure we're not transacting business here with our 5 of 8 members and all these other people here that we didn't invite the other 3 members of the board to? The plaintiffs argued the earlier gathering should be treated as an official meeting, triggering notice. The defendants insisted it wasn't a public meeting. Weird how many showed up for this not public meeting, though. In May of 2021, the local circuit court sided with the supervisor, ruling the gathering didn't meet the legal requirements to be considered a public meeting. The Supreme Court said nah and sent it back, concluding that enough public officials attended the meeting, like 5 out of 8, a quorum, for example, to trigger the law. And the topic at hand met the definition of public business because, it obviously did. Yeah. The state Supreme Court writing, issues related to riots, the use of force by police, the use of chemical agents to quell riots, and property damage were all discussed. That sounds like proper business of the county to consider, but business nevertheless. One of the first responsibilities of the government is to protect lives and safety of citizens. That is true. Protecting safety is good. We should do that. As such, it's hard to imagine a scenario in which the board would not soon address this issue. So, yeah, you probably want to have a meeting, maybe some sort of emergency meeting, but probably open to the public in some way. So, yeah. And that's okay. It wasn't really open to the public, even though 5 out of 8 members and the Citizens Advisory Committee and 60 members of the public showed up, but it wasn't a public meeting. Okay, sure. Thus, that brings us to the end of the case of Virginia and its state-specific FOIA law. This is a matter of Virginia state law. Your mileage will absolutely, completely vary in every possible way in your different states, and for the matter, the federal government. This is a Virginia-specific thing. Virginia says meetings of the government are open to the public. That sounds like a good thing. This particular county had a super secret meeting for emergency reasons, and then had a public meeting 3 hours later. But the super secret meeting doesn't count, even though 5 of the 8 members would sound suspiciously like a quorum, and the police and the Citizens Advisory Board and 60 members of the public showed up. But that's not a public meeting. The Virginia Supreme Court disagrees, says that's a public meeting, which sounds pretty rational. And the Virginia Supreme Court in its decision notes the obvious. If you allowed this as a matter of policy, there might be a lot more secret meetings. If all that counts is what's on an official agenda, maybe a lot more things won't be on official agendas, and that would be dumb. So the Virginia Supreme Court, being not dumb, says you can't do that because of Virginia specific law, so go away and go back and figure out what sort of remedy there should be done about it. And that, for the moment, brings to the end of discussion of this case.